Welcome to the 2024 Phish Studies Conference Video Archive. The Mockingbird Foundation is thrilled and proud to present this groundbreaking video series on our YouTube channel. It continues our tradition of celebrating music education. Since 1996, we have been an all-volunteer nonprofit organization dedicated to broadening access to educational opportunities for youth in music and the musical arts. Please visit mbird.org to donate today.
Okay, everyone, thank you so much for coming again back to our afternoon sessions today. This is the session on Phish and the law. And I just want to grab the name of our sponsor very quickly, because this is a sponsored session. And our session today, which is titled Policeman Came to My House. I was wrestling with a couple of different Phish lyrics to do for this one, but ultimately decided that was the right one. Phish and the Law, sponsored by Farley Wada Witt, which is a law firm in Portland, Oregon, fittingly. Our session today has 3 papers, and the first one is actually, it's going to be a little bit of a different order than what's on your program. So we're going to start with our remote presentation, which is by Matthew Maisel. Matthew is an attorney in Philadelphia, Pennsylvania, who was most recently general counsel for a real estate management company. He is the author of Slave to the Traffic Light, a roadmap to red light camera legal issues. Please join me in welcoming Matthew with his presentation today titled, Wilson, I Lay This Warrant on You, a Prosecution Memorandum on Wilson's Crimes in Gamehendge. Let's all welcome Matthew.
Hi, good evening, everyone. Thank you for having me. Thank you to Oregon State University and Professor Jenkins and everybody else for organizing this wonderful conference. I'm really honored to be here, and thank you for being able to have me speak remotely. And thank you for the wonderful introduction. A little bit of you've already hit on the bullet points of my my biography. A little bit more about me. My first Phish show was July 4th, 2000, and I've been to several dozen by this point. So, as you see on the screen there, today's presentation is Wilson, I Lay This Warrant on You, a Prosecution Memorandum, Wilson's Crimes in Gamehendge. I'll begin with an overview of my presentation today. 1 second. There we go. Okay. So I will begin with a overview as to Wilson's conduct in Gamehendge, which potentially provides the basis for some criminal liability for Wilson. Next, I'll provide an introduction as to the Rome Statute and the International Criminal Court. Then I'll move on to a discussion of the applicability and jurisdiction of the Rome Statute and the International Criminal Court. I'll then move on to a discussion of Wilson's liability for 4 categories of crime under the Rome Statute: genocide, crimes against humanity, war crimes, and the crime of aggression. I'll then move on to a brief discussion as to ecocide, which is crimes against the environment. And then there'll be some time for questions and hopefully some answers at the end. Oh, went one too far. Okay. So in 1988, Phish guitarist Trey Anastasio completed his senior thesis at Goddard College, titled The Man Who Stepped Into Yesterday. One of the main characters is the antagonist Wilson, who's the subject of today's discussion. The following facts are taken from the thesis, which is available on the internet at phish.net. Some of the facts come from song lyrics, and some come from the narration between songs. According to the thesis, Wilson, an outsider, enters the land of Gamehendge, whose occupants are the lizards. Gamehendge is located on the shores of the Baltic Sea. Wilson has Roger, who is Aaron Wolf's son, hanged in a public square at the age of 14 on suspicion of treason. Wilson also has Mr. Palmer hanged for extorting money, which was provided to the revolutionaries. Wilson also seizes the Help Me Friendly book, declares himself king, cuts down all the trees, and enslaves the lizards, and builds a city called Prussia with a castle in the center. So let's move on to a brief overview as to the Rome Statute and the International Criminal Court. The Rome Statute is an international treaty which was adopted in 1998 and it entered into force in 2002. It established the International Criminal Court and established 4 core international crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. Under the Rome Statute, the International Criminal Court can only investigate and prosecute the 4 core international crimes in situations where states are unwilling or unable to do so themselves. Thus, the jurisdiction of the court is complementary to jurisdictions of the domestic courts of the states which are party to the Rome Statute. Now let's talk about the applicability and jurisdiction of the court. Article 25 says that it applies to individual non-state actors such as Wilson. However, 2 provisions of the statute at Articles 11 and 24 provide that it's not retroactive, and thus it does not apply to any conduct which occurred prior to 2002. For the purposes of my presentation today, we'll assume that the acts that occurred in The Man Who Stepped Into Yesterday actually occurred sometime after 2002. Now, Article 12 of the Rome Statute says that one of 2 jurisdictional prerequisites must be satisfied. 1, either the crimes occurred in a state which is party to the statute, or 2, the crimes were committed by someone who is a national of a state which is party to the statute. There's a third way, which I'm not going to get into today, but I will just mention in passing that Article 13b also says that a matter can be referred by the UN Security Council to the prosecutor. So let's first address Wilson's nationality. If Wilson is American, he's probably not, if he's American, he's probably not subject to jurisdiction based upon his nationality. There are 124 states which are party to the Rome Statute. The United States of America is not one of them. In 2000, under President Clinton, the USA did sign the treaty, but it was never ratified. In 2002, President Bush formally notified the United Nations that the USA was withdrawing its signature and did not intend to ratify it. So Wilson is only subject to the jurisdiction of the International Criminal Court if Gamehendge is located in a state which is party to the Rome Statute. So where is Gamehendge? Well, there's a line in the song McGrupp and the Watchful Hose-Masters which goes, "I've alternated my meager flock to the shores of the Baltic Sea." So that gives us a clue that Gamehendge is somewhere along the shores of the Baltic Sea. The Baltic Sea is enclosed by Denmark, Estonia, Finland, Germany, Latvia, Lithuania, Poland, Russia, and Sweden. All these countries except Russia are parties to the Rome Statute. Russia's status is similar to that of the United States in that Russia did sign it, but in 2016 informed the United Nations that it did not intend to become a party. Thus, for the sake of the purposes of my discussion today, we assume that Gamehendge is some kind of semi-autonomous region of Denmark, Estonia, Finland, Germany, Latvia, Lithuania, Poland, or Sweden, and thus Wilson is subject to the Rome Statute to the International Criminal Court. So we'll move on to a substantive discussion as to what crimes he could potentially be charged with. First is genocide. You'll see the definition of genocide there on the screen, but essentially it's certain acts which are committed with the intent to destroy a group. Now, The Man Who Stepped Into Yesterday does not talk about Wilson wanting to annihilate the lizards. Yes, he wanted to enslave them. He wanted to control them. He did want to take over and rule Gamehendge, which he did. But it doesn't, and there were some executions, it seems, but it doesn't seem like his goal was to completely wipe out and annihilate the lizards. So Wilson is unlikely to be charged with genocide. Next, crimes against humanity. So you'll see on the screen there, Article 7 defines certain crimes against humanity, which are, and there's a long list of acts listed there in Article 7, but it's any of the following acts which, when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. The first one there is murder, Article 7.1a. As you'll recall, Wilson does have Roger and Mr. Palmer killed. In addition, at Article 7.1c, another violation is for enslavement. And the Man Who Stepped Into Yesterday, it specifically explicitly says that Wilson has the lizards enslaved. Therefore, Wilson is probably liable to being charged with crimes against humanity, specifically murder and enslavement. Next, we'll move on to war crimes, which are at Article 8 of the Rome Statute. For a defendant to be charged with a war crime, there must be a state of armed conflict. Two excerpts from this article provide some insight as to what is not considered armed conflict. Now, paragraph 2D says, and you'll see two excerpts there on the screen. Paragraph 2D, 2D says that it does not apply to situations of internal disturbances and tensions, such as riots, isolated and sporadic acts of violence, or other acts of a similar nature. Underneath that, you see another bullet point where it says that armed conflict applies when there's protracted armed conflict between governmental authorities and organized armed groups or between such groups. In The Man Who Stepped Into Yesterday, Wilson came to power abruptly. Yes, there was a resistance movement against Wilson, and yes, he did have help from others at times, like Mr. Palmer, Tila, the AC/DC bag. But in Wilson taking power, it sounds like more of a coup. And The Man Who Stepped Into Yesterday does not talk about him leading armed forces. So Wilson is pretty unlikely to be charged with war crimes because Gamehendge was not in a state of armed conflict at the time of his actions. However, for the sake of a complete discussion, if Gamehendge was in a state of armed conflict, I'll discuss what war crimes he can be charged with. Now, two of Wilson's actions stick out as potential war crimes: the executions of Roger and Mr. Palmer, and the theft of the Helping Friendly book. Now, Article 8 of the Rome Statute defines different acts which constitute war crimes over the course of several paragraphs. It also distinguishes between an international armed conflict and an armed conflict which is not international. This is why Wilson's potential violations are organized by whether the armed conflict in Gamehendge is international or not. I'll very briefly explain how Article 8 is organized. And for each paragraph, it lists multiple acts which are considered violations. Paragraph A says that grave breaches of the Geneva Conventions are considered war crimes. Paragraph B is other serious violations of the laws and customs applicable in international armed conflict. Paragraph C is serious violations of the Geneva Conventions if the armed conflict is not international. And then finally, paragraph E is other serious violations of the laws and customs applicable in armed conflicts, not of an international character, within the established framework of international law. I'll direct your attention to the first bullet point under each subheading that you see there on the screen. The top subheading is if the armed conflict is international. The lower subheading is if it's not international. To paraphrase, if you look at the first and third bullet point, you see it on the screen there. Those provisions both prohibit executing someone without a fair trial. You will recall that Wilson has Roger hanged at the age of 14 on suspicion of treason. Wilson also has his accountant, Mr. Palmer, executed by hanging by the AC/DC bag. There is no reference to a trial in Trey's thesis. Thus, these seem to be summary executions, and therefore these executions could violate Article 8 8A4 or Article 8C4. Next, I'll direct your attention to the second bullet point under each subheading, which cite Article 8B8 and Article 8E12, respectively. They both prohibit seizing the property of an enemy or adversary unless the seizure be imperatively demanded by the necessities of the conflict. As you are aware, Wilson stole the Helping Friendly book from the lizards. This action could violate these provisions. However, Wilson would likely defend this by saying this seizure was necessary due to the conflict. The Helping Friendly book, it seems, possessed the ancient secrets of eternal joy and never-ending splendor. Wilson would argue that depriving the lizards was critical to military victory, and thus it'd be up to the International Criminal Court to sort it out. Next, I'll move on to the crime of aggression. Just to give you a little bit of background as to this one, in the wake of the German invasion of the Soviet Union during World War II, Soviet jurist Aaron Trainin made the first successful proposal to criminalize aggression. The Charter of the International Military Tribunal provided criminal liability for waging aggressive war, which was the main focus of the Nuremberg trial. And you'll see the crime of aggression on the screen there, the definitions of it. And I'll particularly direct your attention to the second bullet point, specifically the bolded excerpt, that essentially an act of aggression occurs when there's the use of armed force by a state against another state. As I previously mentioned, Wilson is a non-state actor. He took over an area and a group of people. But the man who stepped into yesterday does not describe him as the leader of an armed force of one state invading another state. So Wilson is unlikely to be charged with the crime of aggression. Finally, I'll move on to ecocide, which is essentially crimes against the environment. And the man who stepped into yesterday, Wilson cut down the trees, which, as I understand it, that was done to clear out the space in which the city Prussia is built. I'll address his liability for this in three parts. First, under the current iteration of the Rome Statute, this probably does not subject him to liability. Currently, environmental destruction is only punishable as a war crime, and thus during a period of armed conflict. As I previously discussed, it doesn't seem like there was an armed conflict in Gamehendge at the time of Wilson's actions. And if you look under the first bullet point there, I quoted the relevant provision of Article 8, the relevant war crime, which is essentially when you conduct a military attack with the knowledge that it causes widespread, long-term, and severe damage to the natural environment, which is clearly excessive to the military advantage anticipated in the attack. However, second, under an earlier draft document, which is a precursor to the Rome Statute, Wilson could have been liable for ecocide. In 1991, the International Law Commission created the Draft Code of Crimes Against the Peace and Security of Mankind, which was a precursor to the Rome Statute. Article 26 covered willful and severe damage to the environment. And you see that definition of Article 26, what was proposed Article 26, listed there on the screen at the second bullet point. However, third, in light of climate change, there seems to be a renewed interest by some countries in criminalizing actions which damage the environment. There's a proposed definition by the Stop Ecocide Foundation, which is listed at the third bullet point there on the screen. A number of countries do have criminal statutes regarding ecocide. Earlier this year, the European Council, which is part of the European Union, formally adopted a new environmental crime directive, which includes a provision to criminalize cases comparable to ecocide. Member states now have 2 years to update their national laws to comply with this directive. So if Wilson committed these actions in the not too distant future, he could be liable for ecocide. Denmark, Estonia, Finland, Germany, Latvia, Lithuania, Poland, and Sweden are all members of the European Union. Thank you for coming to my presentation tonight. I really appreciate it, and I'm happy to answer any questions you may have.
Thank you so much, Matthew. Any questions? If you do have a question, please come down to the front here and ask it into the microphones. Yeah, Ivy.
Wow. Oh, it's not on yet. Great. Wow. This is amazing. I love this. My question is about ecocide. And one thing I've always wondered, and I'm glad you mentioned the updated EU directive, which expands it. But I'm wondering if it depends. I've always wondered if it depends on the lizards having had property laws regarding the property ownership of the trees, and would it also depend on if you could charge Wilson with timber trafficking and also all the associated human rights violations under the EU directive on deforestation? Thanks.
Great question, and you might hear this a lot. I didn't take a very deep dive into European Union ecocide law. So the answer to your question is, I don't know. That's a great question. I'm not sure if being charged with ecocide would depend upon property laws. From what I understand, it's worth mentioning that, as I understand it, the standard for ecocide, it's really high. It's when you do long-lasting, long-term damage to the environment over a very large area, to the point that you've changed the environment, and now I think it threatens the ability of certain organisms and plants and animals to survive.
I love that you asked about it as timber trafficking too. That's great. Tree law. Let's do it. Yeah. Yeah.
Hi, thank you very much. If you view the Helping Friendly book as a sacred text integral to lizard culture and the only copy thereof, is there any statute under which you could charge Wilson with cultural genocide? Not necessarily convict, but charge.
Genocide is when, so I'm not sure if there's a relationship between stealing the Helping Friendly book and killing the lizards. But you bring me to an interesting point, and I didn't have the opportunity to get into it tonight, but there is a United Nations treaty that has to do with stealing cultural artifacts, and I forget the name of it offhand, but there is a statute, there is an international treaty specifically about stealing cultural artifacts, and I think Wilson could face liability under that. But unfortunately, I just didn't have the time to get to it in my presentation tonight. But that's a great question.
I was actually wondering about the new sort of addition to the canonical knowledge of Gamehendge, that there was a French faction of lizards flying a Wilson flag who were at war with the revolutionaries, and the man on the kayak from Punch You in the Eye gets caught up between those warring factions. And I'm wondering if the existence of these heretofore unknown about French lizards turns this into a existing armed conflict between two parties.
Yes, I would certainly think so by that point. If you're describing what it sounds like to me is a civil war, where if you have this desperate, disaffected group of French lizards, and Wilson is trying to maintain control, and then the French lizards attack the non-French lizards. Yeah, I mean, that certainly sounds like an armed conflict to me. And then Article 8 would be triggered, and all the various provisions regarding war crimes would come into play there.
Thank you so much, Matthew. We really appreciate you enriching us with this memo here. Thank you so much.
My pleasure. I'm glad this generated so much curiosity and great questions.
Great, thank you. We can switch back to the other view now. That would be great. Excellent. And let's see. Our next presentation does not have a slideshow, so I'm just going to minimize everything so we can just look at this big swoosh on the screen. Great, so our next presenter is Tony Cullen. And Tony is a shareholder at the law firm of Farley Wada Witt in Portland, Oregon. I love saying your law firm's name, I gotta say. I've been saying it like rhythmically, like Farley Wada Witt. She's over and over.
You can keep saying it.
It's great. It's great.
Let it melt in there.
It also vaguely sounds like a character from Star Wars, a little bit. But
I'll take it.
Which I love. I mean, it's all great. All right. He specializes in creditors' rights and bankruptcy law. He is also a musician and music fan, and the current defending champion of the Best Oregon Lawyer Band competition. His presentation today is called Who Gets Paid or Gets to Say When the Ocelot Can Come Out to Play? How Copyright, Fair Use, Antitrust Law, Two Live Crew, and Michael Jackson's estate each have an interest in one Phish song. Let's welcome Tony Cullen.
Thank you very much, and appreciate you mentioning the firm name. I was thankfully my firm was able to sponsor this panel today, so appreciate that support and you all being here. So just to finish the introduction, since following the prior speaker's lead, first show 12/2/95. So we'll never beat anyone in numbers because I live on the West Coast now and they don't come out here more frequently enough. But and when I lived in New York was the years that they were on hiatus, so unfortunately didn't get enough shows in there. But the claim to fame is that was the last time they ever played Fat. So got one under my belt that a lot of people can't have for stats. So looking at the presentation, obviously we're looking at two issues. One is there any requirement who has a financial interest in a song and who can control whether someone can perform it or not, or reproduce it or not, or what kind of rights they have in a musical performance. So we'll try to get to those issues, and we'll discuss kind of how each one of these topics ties in with the people we mentioned there. So obviously what we're looking at is Ocelot. As you all know, it's got 6 words quoted from Dear Prudence in it. And so the question is, under what rights can they do that, and do they need to pay anything to Michael Jackson's estate, which holds the rights to that song, in order to do so? So first we'll start just with what is copyright, where does it come from, and how does it exist? So it starts actually before the United States is even a country. England had a Statute of Anne in 1710, which was the first time there's ever copyright created as a legal concept. It existed previously only for, basically the control was the control of printing presses, and there was a license for publishers, but it was about the ability to print in a specific area, but it wasn't about the authorship of the work. And so, but when the United States was created in the Constitution, they actually created one of the enumerated rights or obligations of Congress or powers of Congress is to create a system, and it was the way that they phrase it is to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And so those words create both the patent system and the copyright system, or gave the authority to create those systems. And so it's actually, when you look at the kind of the enumerated powers of Congress, that one comes before the ability to stop pirates, before the ability to wage war is that power. And so it's right above the post office and right before and just a couple after the ability to print money. So it's one of those kind of considered a core power. And the reason they want that is obviously to promote the useful science and the useful arts. And so it's by giving a limited monopoly to someone in their creative work to allow them to exploit it is the word that's used, but to basically get some financial benefit from it. The thought is that that's going to create more work, create more creativity, create more, give you the incentive to write a song or to write a book or something like that. And so there's sort of enumerated rights of what under current law, what you can actually control or what you can do. And it's to produce copies of or phonorecords, they call them, to make derivative works, which is to do something that uses some piece of a work or is, a sequel to a movie as a derivative work, that kind of a thing. To distribute the copies out in the world, and to publicly perform that work. And to now there's a digital audio section as well in terms of how to do online streaming or any sort of internet distribution. And the minute you record something, fix it into some sort of medium, like you write it down, you write sheet music, you copy it onto a tape, you put you do a voice memo on your phone, anything like that, it becomes copyright automatically. People often think you have to write that little C, that's no longer required on it, but you basically just need to get it in some fixed medium, including streaming it out. The ones and zeros that you stream out, those are in a fixed medium because they're in a computer and they're physically located somewhere or could be reproduced from that. And so as long as they can be recognized in some medium, that's the copyright attaches to that. But then you need to actually register it if you want to get certain benefits, including the ability to go to court to enforce those rights. So you register with the Registrar of Copyrights, and you do that, and then you deposit a copy with the Library of Congress. So Library of Congress has every Phish album. And another one of the rights is, as a listing, was the performance right. So you've heard of ASCAP and BMI. Those regulate the ability to publicly perform music, and so they. Like a room like this, the university is going to hold a license with those 8 organizations. So there was a band practicing before us that any music that they're playing, they're actually paying a license fee for the right to play that music here. That gets paid through, they have some sort of formula of how they figure out who's played what and how that money gets paid out. And one interesting thing is also within the live performance right, there's questions about the performance, the ability to play a song that you from sheet music or recorded music, but also the ability to play a record and then to have that be a public performance. And so thinking of the spaceship's about to blast off, it's from an audio recording, obviously, the haunting sounds. And so when they're playing that, they're having to license that right to play that musical or that recording. So now we'll get to the first of the items in the title, which was how antitrust law comes into it. So back around the turn of the last century, around 1900-ish, there were player pianos was the big deal of the time. It was a big new technology, and so player pianos are there's scrolls. There's punch holes in a scroll, and that goes air blows, and then from that you can reproduce sounds and have rather than having to hire a piano player. And so one company called Aeolian cornered the market on those scrolls. Basically had publishing rights from a lot of the publishers because they wanted to corner the market on those. And there was a question about whether you could even copyright those because there actually was a Supreme Court case that said you could not, and it was because are they really a creative work or are they part of the player piano? Or are they a mechanical item? And so what happened was, so Supreme Court says no, and so Congress then says, well, we'll create that right because we want to encourage people to make player piano scrolls. And so they create a right and they call it the mechanical right. So even if it's something, a way to mechanically reproduce music, so before then even records weren't copyrightable because they weren't written down. But now they've created the right in the ability to mechanically reproduce music But understanding that the Aeolian Company had cornered the market on the player piano scrolls, Congress tied it to the first and only right that has a compulsory license in it, which is all the other rights. You can get a license, you can get permission, you can get, pay a fee or something like that to be allowed to publicly perform or someone else's song, something like that. But you need to get their permission under most of the rights. But except, I should say, for public performance, because there you're getting the rights by using those ASCAP and BMI licenses. But here, what they did was they created a compulsory license there. They said, we don't want this Aeolian Company to have a corner on the market to be the only one who can make these player piano scrolls. So the way they get around that is they say, we're going to give you the right to copyright those things, but you have to let other people make copies of them and produce their own version of it. And you can do that by paying a licensing fee to the publisher of the song to be allowed to do so. And so that's what gives you the basis of cover songs, comes from that. Because when you want to do a cover song, you want to play Knocking on Heaven's Door, you want to play Dear Prudence, you don't need to get permission from Lennon and McCartney or from Michael Jackson's estate or from whoever else holds rights in a song. You can simply do it by giving them advance notice that you're intending to do so and then paying them this compulsory license fee. And so you give them notice, and it's about 8 cents a song if you do that. There's also a licensing organization that will do it for you without going through the congressional system. But basically, you can get that right, so you don't need to negotiate it. You don't need to get their permission to do so. You can just do it by using that license. So the next right that it can be implicated in, especially in a live stream for Phish nowadays, is the sync right. So most of their shows are streamed online and they're with video. So once you put music along with a moving image, you've created something that is subject to a sync right. And sync or synchronization right is the right to put a musical performance with an image. And so a live concert that shows the band and has them playing a song, those two things are the sync right. So if they're playing Dear Prudence and streaming it out online, technically they should have a license that they've negotiated from them in order to have the right to do that stream. And so it's something that I've thought of that I don't necessarily understand how they do it, whether they ask permission or have a list of songs that they've already pre-cleared, or how they do that. Because when you're playing live on TV on David Letterman or one of those kind of things, they would always pre-clear the songs that the band's going to play to get the license from, if they're playing someone else's song, to get the license from whoever holds that song right. But so wondering, obviously if they're making up on the spot or playing something that's not a pre-scripted set, how they're getting those licensing rights on the fly. Though all of these things, so we've said that the copyright holder has the exclusive rights to control certain things, but there's an outer limit to that, which is the right of fair use. Fair use inherently says someone else has a copyright in something, I'm going to use it without their permission, but under what I believe is my right to use it. And that's the fair use system, and so the one question is it a fair use for them to be using those? And if so, where do those rights come from? And so this is where we get to Two Live Crew. In 1994, there's a Supreme Court case. It's Campbell v. Acuff Rose Music, Inc. So Campbell is Luther Campbell, Luke Skywalker, lead singer of Two Live Crew, and he wrote the song Pretty Woman, which is a takeoff of Oh Pretty Woman. And if you've never heard it, it's as dirty as you'd expect it to be from Two Live Crew, even though it's on their album, as clean as they want to be. But basically it starts with the same bass in the first line, Oh Pretty Woman, and then instantly goes into Oh Hairy Woman, and just gets really sort of all these different things. And it's basically a parody of the song. And so the first thing is they admitted in their papers that it was not, that they could not use that compulsory mechanical license to have made that song, because one of the restrictions is it has to be of a similar style, and a rap song that's making fun of the situation and changes the lyrics is no longer of the same style, so they couldn't use that compulsory license. They actually did contact the publishers and try to get permission to use it, and of course they said, no, we're not going to license you to do that, but they said, we can't let you do a parody. if it's a parody, that's one of the elements in fair use that you're actually allowed to do, which is the right to do a parody. And so Supreme Court gets this case. It's a unanimous decision. And so you've got Chief Justice Rehnquist, you've got Antonin Scalia, you've got Sandra Day O'Connor, you've got RBG. The whole group are there, and unanimously they say that just because it's a commercial use, which is one of the restrictions of, or one of the things you consider in fair use, just because it's a commercial use doesn't mean that it's presumptively can't be a fair use of that. And so it's the basis of commercial fair use. It all comes from this case. And I'll just read a couple quotes from it because it's a hysterical, if you're reading dry legal cases in law school, when I got to this case, it was like the greatest day ever because it was suddenly, it was alive. And so is the Two Live Crew song was clearly intended to ridicule the white bread original and reminds us of the sexual congress with nameless streetwalkers is not necessarily the stuff of romance and is not necessarily without its consequences. The singers, there are several, have the same thing on their minds as did that lonely man with the nasal voice, but there is no hint of wine or roses here. Also, being the Supreme Court, they've got to do, really get really technical on their definitions. So we find out, what is a parody? Parody, the germ of parody lies in the definition of the Greek paradoia, which is quoted as the song sung along another. And so a parody is understood to be you're using a song that's something that's instantly recognizable, so you actually have to steal from someone else or use someone else's intellectual property precisely because a parody doesn't work if you don't understand it to be the Roy Orbison song. If they just did a wholly different thing, you wouldn't get the point of the parody. They also have to distinguish with satire. There you have to go to the footnotes to find out the definition there. But that's where the prevalent follies and vices are assailed with ridicule. And so trying to understand those two of what the difference is actually really matters because a parody is a fair use and is protected, a satire is not. And so Weird Al Yankovic, that's not a parody. That's a satire, and so he actually has to license the songs that he uses for those and generally gets permission to do so. And so they go into this great detail in the case about whether something is a satire or whether it's a parody. And so you have to go through that analysis. So basically, so fair use, it gives you these rights, but the one problem with it, and I've written on this a few times, but the problem with using it is because there is no compulsory license, because there's no necessarily way to prove it, it's a list of factors, and the court says you actually have to look into those factors, weigh them, analyze them, balance them, and so there's no way to pre-establish that you have a fair use. And so you have to do what True Live Crew did, which is you do it anyway when they don't give you permission, and then you get sued, and then they had to spend 5 years in litigation to prove that they had a fair use, that they were, from day one, that they had an absolute legal right to do what they did, but it took them 5 years of litigation to the Supreme Court to be able to prove that right. And so it sort of causes this problem in the law of if you have the right to do something but you can't use it because Two Live Crew had the money to hire the lawyers and to fight the case, but if you're an individual and you want to do something, you want to do something new and creative, you don't necessarily have that power because you're running the risk of litigation to get there against a record company with all the resources there. So the last piece we'll get to is the Michael Jackson estate. And so there, as many may know, just like when we talked about in the Two Live Crew case, Acuff Rose was the person who had the Roy Orbison rights. He had died the year before the Two Live Crew song came out, but he had sold his rights to Acuff Rose, which is a major publisher. It was a Nashville country singer who had started a publication company or publishing company, and so holds rights to tons of especially country and Nashville artists. But so another one is Sony ATV. Sony ATV was a joint venture between a record company and a publishing company, and created this joint venture and holds rights to tons of music. But included in that group is the bulk of the Beatles copyrights. And Michael Jackson was at least one of the major shareholders of that joint venture. And because he passed away, it's now owned by his estate, and they still have that right. And I went to check, and the rights are still held by them. And so the interesting thing about rights, and I guess the big question is why we don't know under what right Phish is using those lyrics in Ocelot or not, is because the only right that's a publicly known item is who is the registered author of a piece of work. So we know it's a Lennon and McCartney who originally wrote it, but we don't know who they've licensed to use it, what licenses are out there, what permissions are out there, any of those kinds of things. The only thing that the registrar of copyrights holds is who owns it, and you can also actually mortgage a song, and so they have lien records of who has sold, borrowed against their catalog. Those can be registered there, and most often are, but those are the only rights that are known. So whether Phish got a license from them or not to use those 6 words, we don't know. It's simply because those types of deals are done in private. So I guess just to wrap up all the pieces together. One, definitely it's a copyrightable song. Obviously, Lennon and McCartney can hold that copyright. They can control the ability of Phish to play Dear Prudence. They license that through those performance rights organizations that are held in each venue that they're playing. But then there is that second question of, what are they doing to get that license to be able to stream those things? It's not a parody because, one, it's not making fun of Dear Prudence or the Beatles, and so it's not going to be under a parody fair use. It's not a mechanical license issue or a cover issue because they're not using the whole thing, and because they're changing the use of it, changing the nature of it by using just a snippet. And so it's likely not going to be a fair use situation. And so the end result is, and this may be less than satisfying, is we don't exactly know under what rights they're using it, but they're using it. And also the situation often is that those who have the ability to defend themselves can do things that others might not. So that's where we are. So that's what I've got.
Thank you so much, Tony. Do we know if Ocelot has a Lennon McCartney credit on it and on the?
It does not. So on Joy, it's listed only as a Anastasio Marshall.
Interesting. Okay. So they didn't pre-seek out any clearance on that, whereas like on Sleeping Monkey is, I believe, credited to Lennon McCartney when it's performed because of that organ. That organ thing from Let It Be that's always in it, right? So technically, could the Michael Jackson estate claim retroactively now that this song does use a considerable amount of Dear Prudence and needs to pay rights on it?
If they hadn't cleared it, theoretically, yes, they could.
If they hadn't cleared it,
yeah.
Okay.
Which again, we don't know for sure if they did or not.
Paul.
There it is. So I was fascinated, or I don't know, I'm trying to figure out the word, or surprised that things have to be pre-cleared. So I'm thinking back to Hampton 2013 when they accidentally ended up playing that Bachman-Turner Overdrive song. I mean, clearly I just assume, oh yeah, they're paying performance rights. It has to be pre-cleared? Because that seemed to me anyway, a total accident.
Well, no. So I'm saying. So what I'm sorry if I misspoke there or wasn't clear about that. But so you don't need to pre-clear. Pre-clearance is about the sync right, the sending out the stream. And so I don't know if they were doing the webcast at that point. But okay. If they were, then again. But there's a few ways it can be handled. One is there actually are situations where there are scenarios where there's people who are basically available to clear on the fly to do those things, or often it's going to be something where they're going to clear it later. Essentially, they're going to take care of it and pay some fee to be allowed to have done it. And so again, the interesting thing again is those who are willing to be cooperative with the system generally don't get sued for these things. It's something that is sorted out because the reverse is going to happen, or the record companies are going to sort out those issues. And so obviously Phish not being part of the major, but they still have enough wherewithal where there's sort of an industry respect amongst people where even if something happens, often it can be clear later. It's those who are not willing to cooperate that then get sued.
So like Bachman Turner overdrives lawyers on Monday morning. Got a call. It was like, hey, Phish played Taking Care of Business last night and streamed it out, and they've wired $2,000 into our account. Like, cool.
Yep.
Anyone else? Yeah, hold on. Let's go down here, and then over here, and then Janan.
I don't know if this makes sense, but I was just thinking about if you think whether or not the fact that Phish is now streaming everything that they're doing, if that has resulted in a reduction of their spontaneity to do things like that because they don't want to find themselves in some funky legal situation, or because you're saying they're generally cooperative, that they sort it out, or are the fees associated with this things that like we might care about, but Phish is like, for entertainment purposes, we'll just pay the fee?
Probably not. So the fees are always just a negotiated thing, and so there's not a fixed amount. The fixed amount thing again is only about that making copies of a cover. It's per record that you sell or per stream that you sell, and so you really are in a situation, and the damages can be $80,000 per occurrence is the statutory damage, and if it's willful, it can go up from that to 3 times. And so you're in a situation where the damages get really quickly, and that's why when you had Napster and Grokster and those things, they shut a lot of them down essentially because the liability was so extreme, because if you're doing thousands of songs, multiply that and you get to millions and millions and enough to make it be material. But so there's no fixed amount, but it's generally is something where it is sort of the cost of doing business, and that's so like in a live show often. Part of one of the fee. I went to the University of Oregon and I produced the shows on campus there for a couple of years, and one of our line items in the concert budget was always the ASCAP BMI license fee, and so you're paying into that license, and there it was for a 1,000-person theater, it was $900 was the fee for a per show essentially. So for the streaming now, it's probably in the tens of thousands, maybe even $100,000, but still that's. Relatively speaking, is something that would be easily covered in their budget in terms of the shows they're playing.
Hi. So you were saying when you record something that immediately grants you a certain level of copyright, right? Is that sufficient to, like if you were to take a song that you recorded, you uploaded it to the internet, and then you wanted to, stream it out, you would have the right to do that without, like, filing any legal kind of paperwork or anything?
Right. So you never need to register to have a copyright. The registration is only required for if you want to sue, and if you want to do certain other things, you need to have registered it. But you obtain it if it's your work and you record it or put it into a fixed medium. Then you hold a copyright in that from the time that you fix it into that medium, and so you hold it automatically. And so there's some people who do the informal copyright. If you write lyrics, put it in an envelope and send it to yourself, so now you get a postmark, and that's useful to show origin, because one of the defenses to a copyright claim is original creation or access to it, and so if someone says you copied my song, but you show from that you wrote it 5 years before they wrote a similar song, that's useful to show that that predated it. But again, you still need to register that to be able to sue on that before. But you can do it after the infringement occurs. You can then register it and still sue on that. It's not going to be willful because you didn't register previously, and so you lose some of those additional rights.
Now, if it's a recording that includes videos, so that would also have to have sync rights, would those be included with just the recording it and like uploading it to the internet?
Yeah, again, it's because the minute you fix it, you obtain all the rights in whatever you do, and so that prevents someone else from taking that stream and doing selling it for money, or that's why they shut you down when people share their passwords on Live Phish when they, are and those kind of things. And so they shut down the streams because they want to have that, and then you're basically illegally republishing it. And so publication is, and the distribution, those are the rights. And so even thinking back to the Napster and those things, people always said people got in trouble for downloading. People actually got in trouble for uploading, because it was the making the copy, not the receiving the copy. So receiving a copy that's not licensed is not the crime, or the statutory violation that gets you in trouble. It's the distribution. And so that's why each case, it's funny, you can see the progression of the technology was each in response to a Supreme Court case in the early 2000s. So you had Napster, which said it was their centralized control that put them as the one who was responsible. They were the distributing party because it was all on their server. So then they switched to things like, so when you downloaded Phish playing Gin and Juice, the violation was the person who uploaded that, not them, but it was Napster who did that. So they're the ones who got in trouble. So then they went to decentralized systems. The problem there, though, and especially when they went to peer-to-peer, is everyone is uploading and downloading simultaneously. So everyone is an infringer when they weren't previously, because as you're receiving a copy, you're giving part of that copy to someone else, and that now you're uploading, and now that's where they can attack that.
I assume the same
I'm sorry. I want to actually make sure we get the last two questions in, but
Okay.
I encourage you to continue this conversation afterwards. Sam, do you want to?
I just have one other.
I know, I understand. I really want to make sure, though, we stay on time.
Sure.
So, but we can absolutely continue it afterwards. Yeah. Thank you. Thank you. Sam, go ahead, and then Janan.
Really interesting presentation. Thank you very much. Fair use, talk a lot about snippets, and the Ocelot example is a very interesting one. I just wanted to throw a couple of other examples at you from Phish and ask your thoughts on these. The first one that comes to mind is the Gershwin in Bathtub Gin, which presumably would be out of copyright at this point, right?
Right.
It's been recopyrighted.
It has.
Because subsequent iteration, the Gershwin estate, I happen to be a Gershwin scholar, Gershwin estate has worked on these things. So.
That's totally identifiable snippet. So that's one question. The second question is the Simpsons theme from the 90s with the secret language, whether that would be. And the third, of course, sort of more extreme example is Trey's Spooky Lick, right? Which is actually, it's known as the Spooky Lick because it basically is the melody from the song Spooky. So does that extend to something that's copyrightable or need to be paid?
Yeah, they all should be. Again, those could be a fair use scenario, but again, you'd have to do the balancing, and there's no fixed rule as to how much is too much. And so some people say 30 seconds, some say so maybe 6 words would be sufficient if all the other factors applied. But there's no hard and fast rule. And unfortunately, what you're dealing is you're literally having a federal judge hearing evidence and just saying, literally going like this and saying, is it too much to this direction? And so and that's why I was actually fascinated that it was a unanimous decision on the Two Live Crew case, because there they all sort of said, no, this is fine. And so, but actually I should say even there though, they were sending it back to a lower court to have more rulings. They said, now that we've said the commercial's doesn't put you outside the scope of this, now you need to go back and say, okay, commercial doesn't knock it out, but have you weighed all the other factors? It sort of settled after that, but it is really this intensive balancing test, and they said that they intentionally don't want hard and fast rules. They want it to be something that's, because sometimes it could be, even if you use a lot, that could be as much as you need to use to have the parity work, and so there's no fixed rule on how much.
Thank you. Janan with the last.
I wonder if any of this can apply to something I've been wondering for a while. In the early days of Live Phish, even before it went to the app and online, this Live Phish CDs, and then in the early days of the Live Phish app or on the website, when they'd release a show, it would say like the Dayton Jam out of some other song, the Cincinnati Jam, the Fukuoka Jam, and they would list them separately with different authorship, and they'd give the authorship to the 4 members of Phish who would jam that. That went away after a while. Do you have any sense of why that would have gone away or why they did that initially?
No, not necessarily, but I'd say that I think that in terms of the attribution, or sometimes you'll even see where things are on the recording but aren't shown in the song list and then appear later, and I think that could sometimes be that scenario. And the bands have always used interesting ways to get around around intellectual property issues. Like my favorite one was the Ramones had a song, Carbona Not Glue, that had to be removed from their second album because the Carbona company, they was first album had Now I Want to Sniff Some Glue. Second album they said Carbona Not Glue because they're switching substances, but they got shut down by that. The first time it was officially released after that, they put it in negative time between two tracks on their live album, and so it didn't show up on the set list, and so that it couldn't be found unless you were listening to the whole thing through, or you went to the track and reversed 2 minutes to get to that song. And so the bands always use interesting ways to get around these things when there's limitations.
And my understanding from a friend who's an IP lawyer has said that I think the length of the song is proportionate to how much rights you pay. So the Dayton Jam coming out of Boogie on Reggae Woman, right, from 12/7/97. Boogie on Reggae Woman is Stevie Wonder, 5 minutes, and then 7 minutes of Dayton Jam, right, or something like that. Yeah. How much are tickets to Phish shows now? Let's thank Tony once again.
Thank you.
Yes. And we actually have only one more presentation on this session. So. Can I use this? Oh, you can. Yeah. That's on the green thing is appointed.
Perfect. Thanks.
You can remind it later.
Yeah. I don't see the cursor there. Oh, there it is.
So our last presentation, I've been eyeing this one the whole time. Rail Riders, Tarpers, and Chompers, a legal analysis of claiming space at Phish shows. Wow, that's so good. Sorry, and let me just introduce Daniel really quickly. So Daniel Dillon is a Canadian and American educated lawyer, professor, and legal scholar. His scholarship on Phish's failed attempt to trademark Fishman's Donut and its effects on identity, performance, and the production of culture will appear in Concepts We'll Ponder, this conference's inaugural book of paper proceedings, which will hopefully be out in the next year or two. And Daniel's paper today, again, is called Rail Riders, Tarpers, and Chompers, a legal analysis of claiming space at Phish shows. Welcome, Daniel.
Thank you. I will not be talking about what space smells like. As Noah suggested yesterday, we might have asked the NASA folks to tell us what it smells like, but thank you to everyone who made this conference possible, including Stephanie, the program committee, OSU, the Mockingbird Foundation, all of the sponsors. Thank you to Farley Wada-Witt and Tony, Michael, and Jake for moderating specifically, and to all of you for being here. Trey is probably in set break at the moment in Toronto tonight. So unfortunately, given the rarity with which Phish or Trey visits Toronto, I'll miss that show. But I'm obviously very happy to be here. You might be interested to know that tickets to this show are going for $19. $19 when I checked on StubHub this morning. No, that's American. I think my lunch at Arnold Hall probably cost more than this. So there you go. I will preface my remarks today with some caveats, if you will. I'm working on this paper, and it's 73 pages at this point. Single-spaced. It's over 40,000 words. I have 257 citations. It's far more complex than I expected it to be. It's obviously a work in progress. I'm going to focus more today on rail riding and tarping than I will on chomping. But I'm also thinking about including smoking and vaping in this analysis, so perhaps keep that in the back of your mind. I'll be talking about these issues in sort of in an abstract sense, a legal sense, but I don't want to give the impression that I'm not mindful of the intersectionality issues and gender issues and other important issues that exist in this context, in this space that I'm talking about. I've read hundreds of Phish.net posts on rail riding mafia, rail riders, please leave the scene. And it was fun in the beginning, but as I progressed through, it got really unpleasant because of the instances of aggression, profanity, misogyny, homophobia, things like that, discrimination, threats of violence. And I don't want to repeat any of those comments here, but I'm sure you're all familiar with them. In the end, the analysis that I perform here, I'm going to share with you, it's been very difficult to draw a clear line on any sort of answer as to what is the answer to this. It's very nuanced, like a lot of areas of the law, very nuanced. And ultimately, I'll conclude that we need some kind of a reasonable balance in all of this. We have to strike that balance first. So the lodestar which guides my analysis is have a good show. Right? This is the common refrain amongst Phish fans. Right? And so why are some people not having good shows? I want to quickly analogize rail riding and tarping to this phenomenon. If you live in the Midwest or the Northeast, you might see people shoveling snow on a public street outside their house where they intend to park their car, where they regularly park their car. And once they have to leave or they've shoveled the spot to get their car out, they want to protect it from other people taking that space under the premise or the notion that they've labored to remove all that snow and they're entitled to that spot. But it's a public street. Anyone can park there. And so you can see here the chairs are acting analogously to a tarp. So this phenomenon exists outside of our scene and exists in other band scenes as well. So I have 10 areas that I want to cover. I'm ambitious in this PowerPoint. It's been difficult. I told you about the length of the paper. I'm trying to reduce it, to stay within my 20-minute time frame, and I'll do my best. But these are the areas that I want to cover. So think about what rail riding and tarping and chomping, what these behaviors are. I think that any way that you would choose to define them is a sufficient way to understand what I'm talking about. There are nuances within it. I mean, chomping, it's talking, but it's also taking photos and doing video and nudging and bumping and things like that. It's more than just that, but any notion you can think of will work. But ultimately, what all of these things have in common is that they seek to exclude others from having a good show. And in a lot of cases, this operates from a sense of selfishness or entitlement, which we may have seen over the last 30 years has becoming more prevalent, not just at Phish, but in other contexts of our lives. And through the research that I did on Phish.net, I haven't even gotten to Fantasy Tour, and I don't think I will. But the views on these issues are fractured. Some people support them, some people don't. So the questions that I'm really seeking to answer are: should one showgoer should be able to, or should they have the right? And right is the language of law, right? And so this is how I approach this problem. Is there a legal right to exclude other showgoers from occupying space in the venue that the first showgoer, the initial one, has claimed and occupied as their own? And if so, under what circumstances? Should one showgoer have the right to demand that another showgoer, not talk or not chomp? And there's a distinction, obviously, to be made there. And if these rights exist, are they enforceable, and how are they to be enforced? Now, for those of us in assigned seating, it's pretty easy how to figure out how to, get someone out of your seat. You could go get security or an usher, and they'll help you to remove that person from your seat. But in the pit or on the lawn, it's not quite as easy, right? Because this is obviously a general admission. It's general admission. And as a result, because of those unclear answers, it really is a fascinating lens through which to view property law. And I guess that's why my paper seems, it's 73 pages, but seems like it's going to be endless because I could go on forever as a theory of everything. So what I'm talking about today applies to GA, but mostly I'll be talking about the pit. And the law provides an incomplete answer, unfortunately. So I've turned to sociology and the concept of norms to help me go where I want to be. So is rail riding, tarping, and chomping, are these behaviors that, are these norms that we, sort of not chomping, but being opposed to chomping, are these norms that we should, foster in the Phish scene? And to get to sort of some conclusion on this, I distinguish space from place and property. It's something that's unformalistic. And that I further divide space into objective space and subjective space. And we heard an interesting presentation earlier today on third space, but I'm going to confine myself to these concepts of objective and subjective space. So we can think of objective space like real property or land, which is usually fixed and it's described by metes and bounds. So for example, this podium is objective space. I am now occupying the space around this podium. But if I were to walk away from the podium, my subjective space is going to follow me. And that is something more ephemeral, right? Wherever I go, I have a sense of subjective space. And there are contexts where we feel people are invading that, for, you know, at the grocery store, maybe standing too close in line, or in the elevator, or whatever the case may be. But even though I distinguish between the two, they can be synchronous and they can be contemporaneous. And so really what I'm talking about in this presentation is the showgoer's claim to objective space, the space in front of Trey, for example, or Mike, right? Not necessarily the space that the person embodies or carries with them. And neither am I talking about title. Title is the root of property. You know, the title to your house, for example, or your car. I'm not talking about that. I'm talking about claiming and occupying space. So we have notions of private and public property been dichotomized and instilled at us from a young age. We come to experience public property, or understand the concept of public property. Common property is kind of rare now, and private property. Public means we can all go on it, private means only some of us can go, namely the person who owns it or exercises control over it. But we learn what is ours, what is theirs, what is yours, what is mine. And this holds true for most types of intellectual property, as Tony's presentation indicated, even intellectual property. But ultimately, enforceable claims of property depend on the political dimensions of property. And that is, namely to say, the legal support and enforcement mechanisms provided by society and the state. Who is going to enforce those rights? But this notion of public and private property is a legal fiction. It doesn't really exist because we don't really own anything. And when we talk about private and public property, we're talking about the relationship we have of things, the degree of control that we exercise over things. We don't really own them. How do I own my house? It's through a piece of paper or something else. But first-year property law students are taught to think of all the kinds of dimensions to the relationships that people have with the property as a bundle of rights. Despite the fiction that's perpetuated by this dichotomy, these two distinctions help us to understand the world in which we live. They also tell us where we can go and what we can do once we're there. It also tells us what we can prevent others from doing, especially if it's prohibited behavior, and how we have to respect other people's choices. We won't, it's not permitted to chop down trees in a public park, and we can tell people not to do that. But I might choose to have a picnic in the park while you might try to play Frisbee, and I have to respect that choice. I can also not go fly a kite in the middle of your softball game in a public space. So we understand, we live this dichotomy. And this dichotomy also communicates certain values to us. And law and social rules amplify and enforce these distinctions. The law of property enforces those boundaries that I'm talking about, which have been, to some degree, fictionalized. But in this sense, when the law steps in, the abstract goes to the material. And so the control that we exercise over property becomes reified. And that is what is important about this. So what I'm suggesting, or my assertion is that a rail rider and Tarper, to some degree a Chomper, is acting as if they are a private property owner when they appropriate, privatize, and seek to monopolize objective space in the pit. So there are 4 different types of property we can think of, and I don't want to let me turn this into a property lecture, but we have public property and private property, which I've already talked about, and quasi-public property and quasi-private property. We'll deal with quasi-property, private property first. So an Air Force base in New Jersey, this is public property, right? It's not owned by anyone. It's owned by it's held by the government in trust for citizens in the United States. But we can't go on there just because we want to, right? There are restrictions on it. So in a sense, it functions like private property. Madison Square Garden in the upper right there, this is also private property, but it's become quasi-public property because the public is invited to enter into this building to see Phish. And it's a form of license then that is given to the person who enters the show. And there are terms and conditions which are attached to such entry. Some are implied, some are expressly stated. For example, not yelling, fire in a theater like this is a norm that should be observed, especially if there is no fire. And if you fail to observe these terms and conditions, chances are you'll be removed from the property. Sometimes we see them at a restaurant or some other, like a shopping mall. We see no shirt, no shoes, no service. You have to abide those conditions in order to enter. So a ticket is obviously required to gain access to a venue. I talked about the printed terms and conditions. They tell us what we can do and what we can't do inside the venue. And you'll see here in this ticket that, as on many tickets, right, no cameras, no videos, no unauthorized recording. So the ticket really is a license. It's a license to enter into the venue. And this is where the legal analysis should end, right? But it doesn't, because the issues are so much more nuanced than just simply saying, you enter the show venue on the basis of a license, and that's the be-all, end-all, because that is not exactly our lived experience at shows. And I'd love to talk about stubbing down, but it's just simply not possible within the time frame that I have, but it's obviously very, very problematic. So you might recognize these fellows. One is John Locke on the left, the other is William Blackstone. And John Locke wrote 2 treatises of government, and William Blackstone's commentaries heavily influenced the founding fathers, the formation of the United States, the Declaration of Independence, the Constitution, and continues to influence policy and law. Locke's main contribution, at least to this presentation, is his notion of labor theory. That a person who labors on something, who mixes their labor with this thing, acquires a proprietary interest to it. And once they've attached their labor to it, no one can take that from them. And Blackstone picks up on this and talks about in rather colorful language about there being nothing better in human existence than being able to exert control over property. Realizing that was several centuries ago, it sounds today somewhat impoverished, or an impoverished view of the world. Nevertheless, Lockean and Blackstonian thinking influenced the creation of the United States. I'm getting to railroading and tarping, I promise you. John Stuart Mill, who discounts utilitarian justifications for private property, holds that first possession theory is necessary in order to resolve disputes in civil society about who owns what. First in time, first in right. But both of these theories are not, are with detractors, right? There are certain detractions. So I would assert that railroaders and tarpers typically rely on these 2 theories, labor theory and first possession theory, to justify each of these behaviors. Occupying objective space, as I've called it, is giving notice to other showgoers that this person intends to occupy that space. And the labor, by waiting in line, waiting outside the venue, that the showgoer expended to acquire that space serves as the basis for making that claim. Additionally, the exclusive use of that space is also justified on the same basis. But then norms become critically important because, as I said before, the law cannot answer this question. As Garrett puts it, most of the time, the daily negotiations of our lives are conducted not in the shadow of the law, but beyond it. And informal social norms, rather than legal rules, govern behavior and the allocation of resources. Claiming and occupying space in the pit is then a resource allocation issue, because the space within the pit is finite. I also posit that the pit is a commons, which is different than paves and assigned seating. A commons, traditionally conceived, and I mentioned earlier that this is kind of a rare thing these days, is an area of land which is not owned by anyone and shared among various persons. It's a shared resource, free from state intervention. And Garrett Hardin wrote in 1968 a controversial essay that where this use is unregulated, unrestricted, where the resource isn't owned by any of them, but they're all using it and sharing it, will trend towards destruction. And so I would suggest that the pit is analogous to a commons in the sense that it is a shared resource. No one has a right to exclude anyone else. No one has a proprietary right to it. But again, keep in mind that I'm talking about space and not property. Once the show's over, we all leave. We don't leave the tarp there. We don't come back the next day and say, I'm still standing on the rail. And I mean, maybe we do, but ultimately what's going to control someone like that is the law, not norms. You'll be forcibly removed or you won't even get into the building. So as I said, we can view the pit here as a commons because everyone has as much an equal claim or a right to be in this objective space as any other showgoer who legitimately holds a ticket. And I say legitimately because stubbing down obviously throws that into problematic flux. Ultimately, everyone in the pit has to occupy some objective space, and some people will necessarily be displeased or less than happy with the space they have. But if there are, for example, 2,000 spots, someone has to be in each one of them if there are 2,000 ticket holders to the pit. But really, that's talking about claiming and occupying space. How does one enforce space that one has claimed and occupied? And so, as it relates to tarping, can the tarp act as a proxy for the space that one has claimed and one is occupying, and as a means of enforcement? You cannot come on into my space. And sometimes the tarp is lifted, other times it isn't. Just to digress quickly, what about exuberant and aggressive dancing? Does this behavior, when, let's say, overly aggressive, interferes with one's show-going experience, is that a nuisance, a trespass? I think of the Halloween show in 2014 at MGM. The person behind me was wearing some kind of a wizard outfit with long sleeves and was dancing really hard, and these sleeves kept hitting me, and was not receptive to my polite request to stop doing that. Nevertheless, it's my favorite show, or one of my favorite shows, so I could overlook it pretty easily. Of course, these things are nuisances on a practical, during the show level, but more serious instances of trespass resulting in assault and battery are properly dealt with in courts of law. What about transference and invitation? Does the railroader or the tarper who claims for themselves exclusively objective space have the right to transfer that objective space or to invite others to share it with them? And if so, is it as potent as the right to claim and occupy that space in the first place? I would suggest that if the answer to that question is yes, then it must be derived from the same principles which justify the claim and occupancy of space. But why would a stranger to this space now be able to occupy it, even though they themselves did not labor to acquire it? And isn't the act of leaving space an abandonment or relinquishment of it? But it's precisely why people ask others to dance with them or share their space, so that this idea of communication, of relinquishment, is not communicated. Also, if a person is waiting for a space to be vacated, does that not constitute labor which entitles them to the space once it's been relinquished? You can see why I've been going on endlessly with this in trying to bring it to some kind of conclusion. What about the showgoer who travels, let's say, from the East Coast to the West Coast or vice versa? Do they expend significantly more labor than the person who goes to simply a local show? If these are both examples of labor, who has the stronger claim? And a lot of the claims are granted in waiting in line, but that's outside the venue. That's not in the pit. You claim an occupied space once in the pit, but you're doing all the labor outside of it. So that might dilute the claim that you labored for this spot in the pit. You labored outside, but not inside. You will labor to keep it, maybe. And tarping is intimately tied up with railroading because it precipitates the same kind of exclusionary behavior that railroading does. I talked about those other points, so I'll just skip in the interest of time. I'll talk briefly about chomping. Right, chomping. I have no problem saying I'm against it. I think it's very bad. But where does the line between chomping and talking, or where does talking become chomping? But if talking is tolerable and chomping isn't, who has decided that? Why have they decided that? But I do consider, and probably at much too great length, whether asking someone to be quiet or telling them not to chomp constitutes a violation of the First Amendment right to free speech. Maybe the difference between talking and chomping is simply volume and decibel levels. But what is this, quiet, we use this phrase in law, quiet enjoyment, is someone interfering with your title to property. So is a chomper interfering with your quiet enjoyment of your space? Obviously they're interfering with the show, but what's the claim? What is chomping? What is it grounded in? And so we return then to these challenging notions of public and private, and in this case, the freedom of speech context. I'll just condense this slide to say, under natural law theory, again, sort of a Lockean view, if speech has an inherent value, it doesn't matter who's interfering with that, right? The fact that speech has been abridged is what matters, right? If this is a constitutional value. But as the Supreme Court has said in numerous cases, time, place, and manner restrictions, and alternative fora for expression under First Amendment speech are acceptable. I think not chomping, while the band is playing, seem to be an acceptable time, place, and manner restriction to impose on chompers, because they can talk during set break, they can talk outside, they can talk out afterwards. There's plenty of times to do say what they want to say or do what they want to do. Am I okay for time, Jake? Or okay, good. I'm almost at the end. Now, I had some white males playing golf here. And I want to talk about exclusionary vibes. Think about a golf course residence. It's newly constructed, and it's advertised. The homes on this golf course are advertised for sale. A condition of purchasing the home is that one also purchases a country club membership or golf club membership. Anyone is free to purchase that home and that country club membership. But what's really happening is that a certain population, lower socioeconomic status, is being purposefully excluded, not on the basis of any law. In other words, only those who can afford a golf club membership and to live on a golf course are sort of responsive to this kind of advertising. And so this is based on this phenomenon which Strelowitz talks about is based on actually owning property. A property owner can do this. Like this is how I'm advertising my residential development to you. But really what he's talking about is the communication of who is welcome and who is unwelcome on the property. And what he also concludes is that you don't have to be an owner of property to communicate this exclusionary vibe. Just occupying it suffices. So I modify his analysis and sort of change it to the concept of whether railroading and tarping specifically has a chilling effect, a chilling vibe on the scene. Because the behavior that we see of some of these individuals acting as if they're operating from a place of right, may communicate to others that they are not welcome in that space. Somehow we're all aware of these behaviors. No one's advertising that if you go to the pit, you're going to get in trouble. but we are aware of what happens there. Sarah Schindler refers to this as psychological barriers to entry. And ultimately, some people might feel that the pit is not for them, that they are outsiders, because they don't understand the so-called rules in the pit and how they're enforced. And so, I've seen multiple fishnet posts where people say, forget it, I'm not going. And I myself have started to avoid the pit simply for this reason. And Tony was telling me a moment ago, apparently at Billy Strings last night, or there was someone put some chairs to guard the rail, and were the chairs being thrown or something? Yeah. And then, the paper that Jake mentioned that it talked about, like even attire can have this same effect. So the scene is fractured about whether these are acceptable forms of behavior. Not so much with chomping. I think most people are comfortable with saying chomping is not something that we should seek to enforce, and being opposed to it is probably okay. Folkways and norms, you're probably all familiar with this, right? A folkway has no real way of being enforced, whereas a moray does. What we're talking, lack of conformity to a folkway really can't be enforced. Lack of moray, yes, through courts of law. And I've already concluded here that law is an insufficient answer, incomplete answer to address the issues that I'm talking about today. Norms are important. They regulate behavior, they set expectations, they also socialize people by giving them or teaching them the values, beliefs, acceptable forms of behavior in that group or society. Provides a sense of cohesion amongst the members, and allows the group to distinguish itself in a collective identity from other groups. So I would suggest that rail riding, tarping, and chomping are catalysts to folkways. And so what I would suggest is that the pit start to be viewed as a commons. Reliance on Lockean labor theory and first possession theory to claim objective space must be reformed to become more reasonable. All fish goers should be free from fear, intimidation, and threats of verbal and physical violence and actual violence, simply because they want to view the show from a different vantage point. And each person legitimately holds a ticket to be in the pit. However, not pushing, not shoving one's way to those spaces that have already been occupied, not violating the subjective space, to displace another person from their objective space should also be viewed as a desirable norm. In other words, we're talking about reasonable behavior, like putting a towel on the lawn so you and your friends and your crew can sit and enjoy the show or stand on the show, not a 20 by 20 foot tarp. Chompers have to accept that there are more appropriate times to talk, not to behave obnoxiously and to negatively impact other showgoers' experience while the band is playing. I'll skip this slide and just get to really what I want to talk about. Don't have a better term. It's the cool folkway that I'm suggesting, where each showgoer recognizes that if they have earned something through labor or first possession theory as a right, that they also have responsibilities, obligations, and duties. So balance has to be struck. And so to just really quickly wrap up, right, in 88, the Grateful Dead issued a letter to its fans saying it with dealing with substances. In 95, at Deer Creek, crashing the fence, and like, hey, if you guys don't stop this, we can't play anymore. We won't play anymore. And it was a very terse letter. Widespread panic, right? Are you home team? Like, they have a manifesto. That scene has a manifesto. Are you home team? And the manifesto guides fans on how to behave. And some of the experiences I've had at panic shows are phenomenal. They're absolutely phenomenal. Some are not very good, but some are phenomenal, right? And it's a common frame, are you home team? I'll quickly tell you a story. I bought a bum ticket when I got to Red Rocks. I went down to the office and I told the whole story. I was living in the Arctic at the time. I traveled like 4,000 miles to get there. Ticket's no good. They said, we can't help you. I'm walking away. Tour manager came out of the office and said, sorry to hear that. Here's 2 comp tickets, and we got in. Like, it was great. And that was all because I behaved politely and respectfully, not because I was making a scene about my mistake of buying, a bad ticket. It should not fall to Phish to tell fans how to govern themselves. Everyone should be cool. I'm not a sociologist, so this might be a pipe dream, but Cass Sunstein, a law professor, talks about norm entrepreneurship, bandwagons, cascades. And so what Ashley is doing with Groove Safe is a great example, right? This is norm entrepreneurship. Trying to change the scene. And if people adopt what Ashley is doing, then we will see people getting on the bandwagon. And the more people get on the bandwagon, we'll see cascades and things will change. Same with free. So I'll just leave it there, other than to say behavior has to be reasonable. So thank you very much for your time and your indulgence and attention. I appreciate it. Thank you.
Thank you so much, Daniel. Our session technically goes till 6:30, so we can definitely have some time for questions. There are 2 rails right here in the front. If you would care to grasp them while needing to ask your questions. And yeah, Hal, go ahead.
First, I'm reminded of the probably annual discussion in New Jersey about whether beach badges can be required for the public beach, which is a public commons. And the second is, it appears that the Sphere adopted a no cape policy because capes could equate to tarps. I wonder if you have thoughts on either of those.
Do I have any thoughts on not allowing capes?
Well, that you're excluding certain kinds of dress because that kind of dress could be used as a cape. The same thing could be said of a shawl, for example.
The same thing could be said of a T-shirt.
Yeah, well, not in my case, but.
Yeah, I'm not really sure how to respond to that. I'm thinking of, when a dog bites someone, that's not a failure of the dog. That's a failure of the person who exercises control over the dog. And so a person who wears a cape should wear it as a cape, not, use it as a tarp, because then you're subverting the whole idea of having a cape, and maybe that's a good thing, but it's a ruse, right? You're sneaking in a tarp where others are being prevented from doing so. So I guess that's my opinion on it. Thank you.
Hi, thanks. I'm wondering about a situation. So you go to a show, you get up, close in the pit with a friend, and you have to take a bathroom break, and your friend is going to stay in your spot to hold the spot. But then you have to weave your way all the way through a very dense crowd and knock a lot of people out of their space to be able to get back to where you were. Do you have a right to return to your space, or if you leave, is your friend just...
Well, I think concerts are fluid, organic entities in themselves, and like the pit is constantly shape-shifting. It's never the same in any sort of particular moment. But I think your question is reflective of what I was talking about. If you've left that space, it would seem to others that you're relinquishing it. You're letting someone else now occupy it. And if there's a certain amount of space that your friend occupies and that you occupied, how is your friend going to occupy both? And how is your friend going to say to the other person, or how's your friend going to say to that other person, you can't stand here because my friend's coming back? What if they say, I want to stand here until your friend gets back? And maybe you can say yes, maybe you can say no. But ultimately, there's really no way to enforce that because everyone who's legitimately in the pit has a claim to space. So that's why I suggest that we've just got to be more reasonable about it.
Awesome.
Thank you. Thank you.
So I'm a big bluegrass guy, and as you know, in the bluegrass world, tarping is a full contact participation sport, right? And so at events like Telluride Bluegrass Festival or the Rocky Grass Festival, people would line up at night, right? Before even the main stage acts are done, they're lining up for the next day, and they would sleep all night in line, ready to get their tarps out. Well, the organization Planet Bluegrass stepped in and said, we can't have this. This is just creating too much of a disruption. It's impacting people's enjoyment. So they started a lottery, right? So you get in line, and at some point during the night, they distribute tickets. So it's kind of sort of takes a bit of that competition out. But it's sort of interesting that here the organization kind of stepped in and said, we're gonna kind of alter the way that we do this. But the other thing too that they did, they sort of created some norming around that when you put your tarp down, anybody that has a ticket can go and sit on your tarp, right? So you're not guaranteeing yourself a space. You're guaranteeing a right to return to that space at some point during the day, but it's not your piece of land, right? People can actually sit in your chairs. If you set up chairs there, you have the right as a ticket holder to go and sit in those people's chairs, right? Which is kind of interesting that they kind of stepped in and made this kind of elaborate sort of norming, but it's sort of a top down, but people bought into it because it seems like the right thing to do. I just wonder if you could kind of comment on that, whether you could see something like that as possible in the Phish scene.
I mean, I haven't heard of that. That sounds really, really interesting. First, I'd like to know who's the person that's going to sit in someone else's chair. I mean, I look at it and say, well, someone's made the effort to bring it and they want to sit there. I'm not going to sit there. I think it's maybe even analogous to, like, taking away ADA space from people who actually need ADA space. And I didn't mention in my presentation, but Access Me and what Mike Site Dyke Site is doing is also important to norm entrepreneurship. I think that might work, but I still fail to see how it might be enforced, because it's like, okay, your tarp's there. I'm just going to put mine over yours because our tarps now have equal right to be there. You're going to come on my tarp, I'm going to come on your tarp. So maybe it's a difference in the scenes. I don't know. I haven't been to a lot of bluegrass shows. I'd like to go, but I don't know. I guess I'd have to give it more thought, but maybe there is some potential there.
So another question you already kind of brought up, going to the bathroom, but I just think that if, let's say you're at a show by yourself,
yeah,
and you're concerned about feelings of exclusionarity,
yeah,
right? And you go to the bathroom and then you come back and you can't go to where you were before, and you don't have anyone to kind of like help you, right, or put you back in your previous position. I mean, maybe if you're in the pit, it makes sense that there's going to be hustle and bustle. But let's say in this location,
yeah,
if you went to the bathroom and came back and some other attendee was in your seat suddenly,
yeah,
you would think that that's rude and unreasonable.
I would, absolutely.
Right. So,
yeah.
I mean, couldn't the I guess the logic cut in the other way?
How so? How do you mean? Can you elaborate? I'm not sure I follow.
Well, so I mean, if you're there with a friend, and as you were saying, the friend is kind of like keeping the space, yeah, for you.
Yeah.
That person is kind of making some sort of claim to objective space that's present against, yeah, other people who are coming into that space.
Right.
Right. But if your friend isn't there, or it's like this situation where you don't have a ticket right to a particular seat,
oh,
but like you've kind of like taken up this objective space, you didn't really abandon a claim to that chair just because you went to the bathroom, because like it's rude to do that to people.
Yeah, I understand now what you're saying. I think that that's a matter of interpretation. I think this occurred on Seinfeld. I don't know if you ever watched Seinfeld, but George goes to watch Breakfast at Tiffany's, I think, at a stranger's house, and he gets up to get a popcorn or something, and this young woman takes his seat, and you have this very discussion. Yeah, I think just the way shows work, the act of leaving the space it matters not what the purpose for it is, and if you don't have a friend, the unfortunate consequences, you'll probably lose that space. And I haven't been there. I thank my own personal God for this, but I've heard of people like defecating, in the pit and urinating in the pit. I don't know if it's true, but maybe Maggie can help me with this. Yeah. Yeah. Yeah, I mean, that's so. I mean, maybe people are so concerned about that aspect of relinquishing space that they don't want to go to the bathroom, or maybe the jam is so good that they just, they come incontinent. I don't know.
I think it's also like a good reason to say hi to your people around you.
Yeah.
Because then when you do leave and you come back, that person might be like, oh yeah, that guy was here. Not easy for everyone to, especially if you're, in your own world. But
yeah.
Ellis.
Yeah, so clarification about reasonableness and a question about reaction to it. If 4 people come put down a tarp that's roughly the size of 4 people, that's reasonable.
I think so.
If one person puts down a 20 by 30 foot tarp and their friends don't show up until showtime, that's unreasonable?
I think so, because if I'm standing next to the tarp and I'm ready to occupy that space.
So if a group of people next to it, as happened at Dick's last year, fold that tarp in half to reclaim part of that space, is that a reasonable reaction, or is there a legal defense to say that they've claimed that objective space?
So, sorry, could you repeat that? They folded it in half? I'm trying to visualize this.
Yeah, so one guy puts down a 20 by 30 foot tarp. He's constantly looking at his watch, but it's a performance. His guys show up there at 7:45. Group of people who I'm with next to them just folded his fucking tarp in half, yeah, and said, you don't get that space.
Yeah.
your guys aren't here.
Yeah, okay, now I get it. Yeah, I mean, I think that's reasonable. I think that there's sort of the give and take that I was suggesting is that, if you're going to take from the scene, you've got to give. And so, or if you're going to give to the scene, you can take back, right? So we've given you the chance, your crew's not here. How much longer are we going to wait? I mean, show's about to start or whatever. We'll give you half the space. We're taking it. Maybe we can work out something later, and we can give up some of it or whatever. But to claim that space on the promise that someone's going to arrive and exclude others, I think is problematic, especially if they're right there waiting. Like, I'm here. I have a ticket. I can stand there. Why can't I stand there? I mean,
Thanks. This is so tremendous. I feel like we need 8 more hours or years of this debate. So thanks. I'm wondering what you think about. I'm thinking of enforcement of norms and the band's role in it, and particularly thinking about the evolution of the early entry lotto, which seemed to be sort of an attempt to democratize and reduce the amount of labor that people were spending, therefore being entitled to it. But I'm not sure that we're getting to that sort of meeting of that expectation, because now some people feel perhaps more entitled because they have a higher number than somebody else, or all kinds of other mischief going on. So.
Yeah, I mean, I kind of skipped over it. I mean, the wristband acts as a proxy into the pit, and I guess that's a reaction to attempt or to regulate who's going into the pit. And I thought about this, and I thought about talking about it today, and if anything more or anything different is done, it ceases to be general admission, and we're sort of back into an assigned seating situation. But I think it's not for me at this moment in my life, but I think I can appreciate that people love being in the pit, and that there's a tremendous energy there. And it's healing and restorative and transformative for so many people. And I think it'd be lost if now you're confined to a particular space, either through lottery or some other system. So I don't know, again, despite all the work I've done, I don't know if I have a really good answer to that. And I wonder why, maybe Phish tried it and realized that there's just, it's going to be too much for them to regulate. I talked in the abstract. I mean, some pits are smaller, some pits are larger, some venues are better than others. There's so many things that are actually going on. But yeah, I hope that's a satisfactory answer. Yeah, thank you.
I think we'll have one more question, then we'll wrap it. But yeah, Noah, go ahead.
Hi, thank you.
Yeah.
Very interesting. I know you said that you're putting aside the issue of stubbing down for this purpose, but if I could just ask quickly,
yeah.
Could you talk about what's problematic about stubbing down in a context where you have 6 people in 4 seats, but you don't go beyond the 4 seats that you've been allotted? Or 10 and 6 or something like that.
Well, I mean, you want to put 6 people into 4 seats?
I'm not going to say I haven't done it.
Okay. Yeah.
I'll just say that, I'm always like, how? But you're not enjoying this anymore, are you? Right? I mean, maybe you are because you're with your 5 other friends instead of just 3 other friends, right? But sometimes this happens near me, and I always am wondering, how are you enjoying this now that you've got 5 people in the space of 3 seats? But
I guess in the abstract like that, it would seem, okay. But whatever everyone starts doing it, right? All of a sudden, the row that I'm in and the space that I'm designated to occupy is being crowded, and then
So is that the categorical imperative is being at work here?
Maybe. I mean, I don't know. I don't really. I say that a line in is hard to draw, and I don't know personally where I land on these issues. I kind of want everyone to have a good show, and so if it's reasonable, I don't know. For example, if you go on a flight and you don't check a bag, why is the person next to you who might that's not a good analogy. Never mind. I guess it just varies with the situation. Yeah, it really does. And so I don't think it's wrong per se, but I think it can make people uncomfortable. So
if I can jump in real quick, just an example of that, what you're saying, where sometimes it's not limited to that space. Island Tour 2, I put in the tremendous labor flying cross country to be there. Decided that the second night at Nassau I wanted to be on the floor, bought a floor ticket, show up. The floor's so oversold, plus everyone's stubbed down so many times. The fire marshal is standing there and won't allow me to the floor. And so it was an overuse of the commons, and all those extra things then infringed on where I actually had that ticket, had the right to occupy that space and couldn't. And then the worst part is I don't have a seat now. Now I'm going around inside the venue and having security hassle me. Get to your seat, get out of the aisle, get out of ADA, and there's just literally nowhere to go and sort of ruin the night because of that situation. So it has real consequences.
Yeah. I mean, sorry if the show was undersold, and I can't imagine that if, a Phish show these days, fine, no problem, obviously, but not to be flippant, but.
All right, so I'm going to slip in one more. The rail and the field are one thing, but can we stipulate that there are places that wouldn't be reasonable to claim as objective space, like aisle monkeys are out of line, right?
I think so. I don't know. I answer that question from a legal perspective, and the answer is that's unreasonable. But as a showgoer and a human being, it seems okay, right? But one of the threads that I read, was a detailed account of how the person couldn't get back to their seat because quote unquote wooks were blocking them from doing so, right? And this story that's retold in the Phish.net thread, this person had to walk all the way back, up the stairs, go around and come down the other side and then push their way through, the opposite end of the aisle. That seems ridiculous to me, So I don't know. Again, balance, being respectful, you can stand in the aisle and dance in the aisle and have fun. I got no problem with that, but, be cool.
There might be a difference also between the person, if the aisle is right here, the person who's dancing like this in the aisle versus the person who's just like a step out of their aisle seat, maybe, right? I don't know. Ooh, this just keeps going. All right, Sam. Yeah.
Very quickly, what about the stairwells as ingress and egress? No, this is not a joke. As ingress and egress for fire escape, medical emergencies. I mean, when you're packing the stairwells, not to mention, you're sort of infringing on people's right to go to the bathroom.
For sure.
So maybe talk about those things.
Yeah, I suspect, I talk about this in the paper as well. Each venue is different, right? Like we behave differently at Alpine Valley than we behave, at MSG. And I think it's venue specific. That's obviously a problem. If there is, the unfortunate situation that we need to evacuate like that, it'll probably be mayhem anyways, and the people in the aisle will probably, in the stairwells, will maybe just have a head start. But I don't want to give the impression that I'm subscribing to a sort of cerebral, formalistic experience of the show. I'm not at all. There's lots of space to be. It's just being respectful that other people have, at the cost of going to shows now, maybe saved up, right? And they're there to see maybe 2 shows or 3 shows here instead of 10 now because they can only afford to do so, and they want to have a good time. And it's so simple and it's so easy to just respect other people. And maybe I'm talking about something grander or larger, it's endemic in society than I am just about, these behaviors.
This is just a comment for the Akashic Record of Phish. There's a lot of ladies, and
yes.
they're physically smaller than the gentlemen.
Yeah, 100%.
And the gentlemen there's a lot more gentlemen doing more drugs and alcohol than maybe they should be. And there's a lot of charge on what's happening down in the front. And the truth of the matter is that there's just a lot of ladies down there who'd like to see the band and would like to dance. And there's a way that that gentlemen will come into the space because they want to be close for a while. And the gentlemen who are there in the space are defending the space a little too violently for the sake of the ladies around them who are small. And somehow people don't notice that the space they're trying to occupy is actually currently occupied by a lady.
Yeah.
And I just feel like when we turn this into a neutral legal conversation, we lose that aspect of what's going on. There is a lot of angry people in the front protecting the space, but they're protecting the space for the smaller among us who, you know, get stomped on pretty regularly.
Absolutely. I didn't mean to give the impression that that doesn't happen. I said in my preface, like talking about the intersectionality and the gender issues. And I mean, I'm talking about it in the abstract, but absolutely I'm talking about the kind of person, and I wouldn't use the word, I mean, the ones that are defending, I might say gentlemen, but for the belligerency of people who come and threaten, you know, people, I presume like yourself, that are in there trying to enjoy the show, absolutely. I mean, that is so problematic. And I didn't want to give the impression that I wasn't sensitive to that. It's just sort of trying to talk about these behaviors in a very
I just think
general
we
sense.
have to talk about the
Yeah.
time, you know what I mean? And I
Yeah.
hate that people are mean during the show, but I also hate that people come storming through.
For sure.
Anybody can go stand in the line outside in the afternoon instead of visiting or bar hopping or all the things we like to do during the day and befriend the people in the line. And then that's what happens. It creates a network of people around you so you can go to the bathroom and come back and know you can come back and dance in a commons. You know what I mean? It's
For sure.
Part of the experience is building the relationships.
But, okay, I mean, I agree with you, but what your earlier comments suggest that their reactions to not being able to do that in the first place, right? So the fact that space has to be guarded is a response to the fact that it's not safe to be in there unless the space is guarded. What I'm suggesting is that it should be safe for everyone just to be there, that you don't need to be guarded, and that someone shouldn't push and shove, they shouldn't threaten, right? But I am absolutely very aware of the gender differences for sure, and I understand, like, I absolutely.
We're also talking about like the actual lived experience of the show and the GA spaces versus a sort of abstract theoretical legal, and not that we should favor one over the other, but the two are, this is of a value in and of itself outside of the lived experience
100%.
because it's interesting to consider it from an abstract point of view, not to say that this is the more important one or anything.
Absolutely.
Right? Yeah.
Like the lot. I mean, lot is like a great. I also talk about that, or want to talk about that, right? And I think that's what you're talking about. It's like forming friendships and meeting people, and preparing for the next show, or talking about the previous show, and all those things. And these behaviors are imbued with that and part of that. And I don't want to give the impression that I don't value that either. So yeah, thank you.
I just want to counterpoint to the lady. As a very large gentleman, I am the last person anybody wants on the rail. I have been physically yelled at, abused, had things thrown at me when I earned my right to be at the rail. If my name's not Bill Walton, he's the only person that's allowed the rail above 6 feet tall. So it's a double standard too. The ladies are allowed up front because they're short, and that's great. They're not blocking anybody, but a gentleman of my size, get in the back. And I am not welcome in the pit. I don't feel welcome in the pit. No matter where I stand, I'm blocking y'all. There's always plenty of dancing room behind me. But nobody wants the dancing room, they want to shove in front of me. And so I spend half my show getting shoved and pushed around because they just want to get in front of me. But I earned my spot too. And so I spend my time in the back of the theater because I don't want to fight with y'all, I just want to dance. But there is a huge number of us men, larger men, who have been completely shut out of that system. I don't know what it's like to be on a rail at a Phish show. I got second row at Alpine in '98. Through mail order, thank you very much. That's the closest I'll ever get to a show because I had a seated ticket and I was allowed to seat there the whole time, but that doesn't exist anymore. And then the other piece I just want to touch on was the larger problem. If anybody was at the Charleston shows in a couple of years ago, where the entire venue was general admission, not just the floor. And like literally we walked in there an hour and a half before showtime and every seat was claimed. And it kind of looked like this. But there was, coats everywhere. Oh no, I'm saving this for my 5 friends, and my 7 friends are sitting there. Literally, we were sitting 5 rows from the top, looking down a tray down there, an hour and a half before the show because everybody was so entitled to save so many damn seats. So I personally am a big anti-general admission person. Pay for a seat, sit in your seat, enjoy your show. If you got a second row, fantastic. If you could score a front row, fantastic. If you're 10 feet tall or you're 5 feet tall, you paid your ticket, take the ride. But in general admission, there does become this unspoken pressure. If you're too tall or too fat or any other issue, you have a costume that's weird, you better get the hell out of the way. So.
I want to just say also, I think that issue can also be solved by the same issue that we are talking about here, which is the everybody be cool, you know, and like which is to say, like, you know, the and I don't want to turn this into a referendum on gender roles in general admission spaces, but that, like, you know, men need to be cool to women, and the women need to be cool to men. Everybody needs to be cool to each other, right? And that is an ideal that we are working on, or that we need to be working on, right?
Absolutely. Yeah. Thank you.
Yes. Okay. So forgive me if this was covered during the few minutes when I had to step out, but you opened with have a good show, and the premise of have a good show.
Yeah.
Now, for me to have a good show, the difference between having a good show and having a cathartic, life-affirming experience that I go to Phish for time and time again, that makes going to a Phish show to me so different than going to just about any other show, is that I get to be able to dance myself clean. As Trey says, he said when he looks out and he sees people dancing and they're dancing all freaky, it's so that they can shed the bullshit. Yeah. And that really speaks to me, because when I dance, it's to get to a state of mind. It's to get to this trance state. And part of that's the endorphins and the runner's high, but it's also just to literally be in the moment and shed the bullshit and experience the transcendence. Now, that being said, I'm very aware of my surroundings, and I try to be respectful, and I know where the people are around me. But I find that when I go to the pit, the reason I go there is because a seat doesn't have enough space for me.
Sure.
And the floor, I don't take up an unreasonable amount of room, because that'd be one thing to request a 5x5 or a 10x10 space. But I take up more room when I dance than just me standing. And so sometimes if the band is playing a song, or if I'm taking a pause and somebody sees a little bit of extra space and they go there, right? And I have to explain to them, I'm sorry, but I'm dancing here, right? And to them, they see negative space, they see empty space, and it's such a like there's two sides of it. On the one hand, they deserve to have a good show, right? But on the other hand, I did the lottery, I got there early, I put hours in so that I could have the extra 6 to 8 inches around me, just so I can have from an okay show to an incredible life-affirming experience that I'm going to be talking about 30 years later, And so in that case, who has, does one side have a legal argument over the other? Because in my mind, it's sort of like, well, we both deserve to have a good show, but I was kind of here first, and if you wanted to be here first, you could have been.
I appreciate your comments for sure. Unfortunately, the legal answer is quite unsatisfactory. I mean, right? I mean,
so for me, I guess it turns into a reasonable amount of personal space. One ticket in a GA floor has a reasonable amount of personal space.
For sure.
And so when somebody else comes in, I feel like the language would change, and our perception of it would change if somebody that I didn't know came and was literally on top of me, right? But that's how I feel with how I dance. If they're right here, to me, just because they're not touching me, they're preventing me from being able to just do like that even.
I think it's context specific. I mean, it's show to show, venue to venue, pit to pit. I mean, how many people are there? And is your claim, reasonable balanced against that other person? But why are they coming to occupy your space if they see you're dancing and having a good time? I mean, why would they choose to do that?
That's right, and that's what I always tell them. I say, look, there's plenty of room for you to still have a great show right here.
Yeah.
Just please give me the extra 6 inches right here.
Yeah, I mean, we all have to occupy some space, right? Someone has to be in front a tree, or someone has to be in Lakeside or wherever, in front of Crota or whatever, right? Someone has to be in that spot. You can't just keep everyone out of it so that no one enjoys it, right? So someone's going to enjoy it, and someone's going to be unhappy, and so you didn't get there early enough, so you suffer, right?
We are 6 minutes past the end of this session, so I'm going to call it here. I do just want to say,
Thank you, Benji.
This is obviously a very personal topic for so many of us, because we're talking about each of our individual show-going experiences, and especially if you are a person who does spend any time in a GA space, it feels especially more personal. And so I just want to acknowledge that and say that I encourage everyone here to speak in person with people around them here who maybe who you agree with or you disagree with, but I think we can all approach this from the same basic premise that you said, which is have a good show. Let's all approach these conversations, these very personal conversations, from a point of view of we all just want to have a good show, and how can we do that better for each other, right? So again, I think let's thank Daniel for really giving us so much to think about, so much to chew on, and really providing this unique perspective on this experience. There is a